All right. We are live on YouTube and we are also recording this. And at this time, the court is going to call case number 08-20-00171-CV, City of Georgetown versus Terrell Putnam. And Mr. De La Fuente, we have a timer up in the corner of the screen. You will have 20 minutes. Mr. Lovins will have 20 minutes, and then Mr. De La Fuente, you'll have 10 minutes for a rebuttal. And so it's red, yellow, and green. So obviously red means your time is up. And usually the yellow light, if I remember correctly, about 3 minutes before your time is up. But at any rate, before we just let you know that the court has had an opportunity with our staff to review the briefs, the records. So we are acquainted with the facts and the legal issues in this case, if that aids in your presentation this morning. So thank you. Mr. De La Fuente, you may begin.
Thank you, Your Honor. And may it please the court. I'm Joe De La Fuente, and I am here representing the City of Georgetown, asking you to reverse the trial court's denial of plea to the jurisdiction and to dismiss this case. Appreciating that the court has read the briefing. I do think it's helpful to frame the case in terms of the important fact and the important legal issue. And the important fact here is that, as admitted by the appellee, from its inception, this lawsuit has always been about a very specific legal dispute, whether the city's payback analysis is subject to a competitive matter exception. We agree. And the important fact there is that the payback analysis has been produced, has been revealed in its entirety, with no restrictions, has even been filed in open court. And thus, as to the dispute, that fact is the dispute has been mooted. The important law, jurisdiction. As this court knows, jurisdiction is the door through which every case must pass, and it has to be an open door. Otherwise, the trial court can't take any action. And the two doors that the plaintiff and appellee tried here were actually closed to him. The first was a Public Information Act injunctive relief claim under .3215 that is not open to him. Only a county attorney or district attorney with respect to city can do that. And the Uniform Declaratory Judgment Act door, through which he tried to pass, is not available when, as here, a plaintiff seeks a judgment as to the application of a statute and his rights thereunder, as opposed to challenging the validity of it. And this is something that's important, Your Honor, and I'll be getting there. A few new cases have come out since briefing that we'll be sending to the court courtesy copies of at the end of the day. And one of them is City of Austin versus Doe from the Third Court of Appeals, which considered the Uniform Declaratory Judgment Act in the context of a Public Information Act challenge and held exactly that. The Uniform Declaratory Judgment Act does not allow you to adjudicate one's rights under the Public Information Act. But of course, we don't even need to get to those two doors of does he have a 3215 claim or a UDJA claim. When the case is mooted, it is mooted. The payback analysis was produced and is part of the record. And as every single case in Texas that have examined a Public Information Act question where the document has been produced, every single one has found the case is now moot, going all the way up to a case just from February of this year in the Corpus Christi Court of Appeals, a UT Rio Grande Valley versus Hernandez. The exact same fact pattern. A particular video was sought, the entity produced it, the case is mooted. And it can be mooted at any time prior to final judgment. The Giggleman case out of the Third Court of Appeals and Deere v. City of Irving tell us that as well. Even after an interlocutory summary judgment, production of the document moots the case. So maybe it helps the court a little bit to understand the landscape of what the City of Austin did, City of Georgetown did in this particular circumstance. City of Georgetown got a request. It appropriately sought an Attorney General review and opinion as to whether exceptions to the Public Information Act applied. The Attorney General said, yes, they do. The competitive matter exception applies. And then the city later realized, for an independent reason, that the document at issue was public and was thus public information. And once the information is public, it doesn't matter what exceptions might have applied to it. It's a public document. And so under the Public Information Act, you've got an obligation to treat it as such, which is exactly what Georgetown did here. As counsel in litigation, once suit was filed, did due diligence, realized that the document had been posted on a public site, the city had to treat it accordingly, produced it, even filed it in open court, made it public, and the case is over.
Counsel, if I could just clarify something on the facts. As I was kind of looking at the timeline, it looked like November 2006 is when the request was made, and then the city responded and got the AG's opinion in December 2016. And then it was about 20 months before suit was filed in August of 2018. Is there anything in the record that tells us what happened in that 20-month period?
I don't believe there's anything in particular that tells you what happened in that 20-month period, Your Honor. I don't think so. I mean, fundamentally, the inflection points were again, after suit was filed and they're contesting the question of the payback analysis. The city, doing its due diligence, realized that the document had ended up being made public. It's on it in a totally separate way. And because the document's now public, you can't in good faith maintain that it's not public. So, I mean, it's in the way we think about it kind of like attorney-client privilege and waiver. I mean, you may have gotten a good opinion from the Attorney General that it's attorney-client privilege, but if someone later brings to your attention, hey guys, you posted that memo on your website, well, gosh, you're right, and then the privilege is waived, so we would be in bad faith if we stood here in court and continued to maintain that. It's now public. Doesn't mean that we agree that the information therein wasn't originally attorney-client privilege or anything like that, but as this court well knows, once an exception or privilege has been waived, it's been waived. The document's out there. So that's the fundamental inflection point of the timeline. So getting to the point that is that production, this case being about one request for one document with a single unique set of circumstances to what may or may not apply exception-wise, that's over, and nothing since the disclosure can change alter the status of the parties with respect to that dispute. It's done. Now, the court was presented with arguments as to exceptions to mootness, and whatever you want to call them, the subject to repetition while evading review, or the public interest exception that we don't think actually does apply, but it does exist. But in any case, doesn't really matter. They all encompass the same logical test, and it is, does the wrongful conduct, the case of the Supreme Court of the United States calls it the challenge conduct, is the wrongful conduct subject to repetition while evading review? And that can't apply here. It cannot. And practically speaking, it's hard to imagine how it would ever apply in the context of Public Information Act. I mean, unless you had an entity that simply refused to respond to PIA requests, got them, just never responded. That would be illegal, and maybe that'd be subject to repetition. But in the context of receiving Public Information Act requests and taking a position as to each unique request and the unique information sought therein, it's impossible to repeat because everyone is unique. And again, I use the attorney-client privilege because that's something we're all very familiar with. And it is actually one of the exceptions to the Public Information Act is, a governmental entity doesn't have to produce attorney-client privileged information. As we know, that is a request and item by item specific inquiry. What may be privileged, what may request privileged information today, the next request may not. And whether a particular piece of information is privileged or not may be or may not be the case. So it's really hard to provide general guidance as to, well, you've asserted the privilege before, so I'm going to tell you it doesn't apply in this case. If it does or doesn't apply in that case, it has no bearing or instructional on how it would apply in the future. As an attorney, I've asserted the attorney-client privilege hundreds of times in my career. Most of the time, it's been sustained or not challenged. Occasionally, I've submitted a document for in-camera review, and the court says it's not privileged. But it's examined on a case-by-case basis. And the second is Again, it really can't be repeated because it's unique. But even if you took the concept of the challenged conduct being as broad as the appellee would state it here, of simply asserting an exception to the Public Information Act, well, two problems with that. One, that's not wrongful. It's literally established as a mechanism by the legislature to assert exceptions to the Public Information Act, present it to the Attorney General for consideration, and proceed accordingly. The second is that sort of act absolutely does not evade review. It is regularly reviewed. It's reviewed by the Attorney General. Then it can be reviewed by courts in multiple ways, and has been multiple ways. The Gates decision that we cited noted and expressly found that Public Information Act exceptions are regularly reviewed. This one has been reviewed. And in fact, this one has been the subject of AG opinions 418 times in the last 10 years, which is actually a little less than, or a good bit less than many other exceptions. The reason for that being that of all the entities in Texas subject to the Public Information Act, only a small group have public electric utilities. So only a small group would have this exception available to them. But in every single case, there's all kinds of cases where this is considered and exceptions are reviewed and again, regularly reviewed all the way up to in the last week. There is a new case from the Third Court of Appeals, Qatar Foundation v. Zacor Legal Institute, which that opinion isn't reviewing the exception, but the case is an exception challenge that's working its way through. That opinion is a jurisdictional challenge, but literally came out April 15th. And likewise, there's another Franklin Legal Foundation case from December from the Third Court of Appeals, considering multiple exceptions. And again, we'll provide copies of these cases for the court's review.
Counsel, if I could interrupt you again, I'm sorry. Is there anything in the record that tells us how often these payback analyses are filed or involved in projects? In other words, is this something that comes out every year, or is it very project specific? And then my second question is what is the record citation for the 418 AG opinions that deal with the competitive exception?
To your first question, Your Honor, I don't believe there's anything in the record as to the nature of the payback analysis, except on the face of the document, it's project unique. Whether or not the city does that with any other projects, electrical or no, honestly, I couldn't speak to it even if we put it in the record, I would know it, but I just can't speak to that. I mean, the competitive matter exception encompasses quite a bit of information and types of information, contracting, things that discuss pricing of power that you acquire. So as to how unique the nature of this document is, there's no evidence in the record one way or the other. As to the 418 times that it's been cited, I would have to point to the brief, and while Mr. Lovins is arguing, I can dig that up. It's in our brief, but we simply cited to the Attorney General opinions themselves. They're a matter of a search of Attorney General opinions with discussion of this particular numbered exception. Have considered it at least in some way, shape, or form that many times. As to how each one was decided, et cetera, we didn't cite or discuss that. With that, and I don't want to belabor the mootness, although again, I think that is the threshold issue. The mootness, as discussed again as recently as the UT Rio Grande Valley case, it follows a very set pattern. A requester challenges the public entity's conduct, withholding of a document, the document's produced, the case is mooted. And maybe what this does is it does give us a little segue into what mechanisms the Public Information Act allows and provides for. Most of these cases, as pointed out by the appellee, are .321 mandamus cases, which is the mechanism really that's available to a requester. they point that, well, it's not a 3215 case, which we brought. And they're right. Most of these cases are not 3215 cases because requesters can't bring those. Only county attorneys or district attorneys can bring those. And in fact, this court, in its McNabb decision, was considering one of the unusual 3215 cases, and did find, that again, the action has to be against the entity that is withholding the document, implying that you have to have that wrongful act. But that does dovetail us to what is or is not available to a requester in the Public Information Act context. What's truly available is a 321 mandamus action, which is what you see examined over and over and over in all of these cases. However, in this case, when the document was produced, appellee did the right thing. They dismissed their 321 mandamus claim. There's nothing to mandamus. But they tried to maintain a 3215 claim that they don't have anymore. They don't have any claim. Under the Public Information Act, you can bring a 321 claim, and a complainant can make a complaint with the county or district attorney under 3215, and the county or district attorney can bring the case. In the new Qatar case, actually from last week, does observe exactly what 3215 does and the order of operations. The complainant complains, county attorney or district attorney brings the case. There's another mechanism by which a requester can be in front of the court on a Public Information Act request, and that is if the city appeals and appeals the AG's decision denying its request to hold something back, the requester can intervene. But those are it. Those are the doors. Fallon, Sevchik, and the new Austin v. Doe case all tell us definitively the Uniform Declaratory Judgment Act doesn't provide a mechanism, because that's a limited waiver to challenge the validity of a statute, not to adjudicate rights under a statute.
Counsel, has the Austin court ruled whether there's a private cause of action under 3215, or is that still an open question in the Third Circuit?
It's a marginally open question. I'd suggest that they're speaking to it rather directly in the new Qatar case, in that they do describe the order of operations in that 1-2 punch way. They describe a 3215 action as a complainant makes a complaint, and then the county attorney or DA files a suit. And frankly, the plain statutory language matches that. There is no mechanism in that plain statutory language for a requester to bring a declaratory judgment claim. There just isn't.
So, Mr. De La Fuente, can you just clarify, was there any period of time here that there was a valid cognizable claim?
There may have been, and without reaching the question of whether the mandamus is appropriate to order production of something the Attorney General has ruled doesn't need to be produced. The day the claim was filed, at least arguably, the day that the claim was filed and the document had not been produced, to the extent there would have been an ability to mandamus when a city was obeying an Attorney General opinion, then there would have been there could have been a live claim. I'm not honestly, I don't necessarily know, and I don't think we have a lot of good law on whether mandamus is there when you're following an Attorney General directive, but hypothetically.
Mr. De La Fuente, let me ask you. So the Attorney General gives an opinion. Correct me if I'm wrong, that's an advisory opinion, right? I mean, that's not a directive, that's not law, that's not binding. I mean, a court could come to an opposite conclusion. Am I right? But at least it's colorable in the sense that they sought an opinion and they have an opinion that backs up or buttresses their decision in not releasing that information, right?
Absolutely.
Okay.
And
so
again,
a requester, even though the Attorney General has rendered an opinion that the information is protected, a requester can still go to a court of law, file a lawsuit, ask for the information, and the court and the appellate court on up the chain can rule against whatever opinion the Attorney General has rendered.
I generally believe that is the case. I mean, functionally, it goes both ways. I mean, I'm representing the entity. I'm much more often a party to the case the other way, where the Attorney General tells us, no, you can't withhold this. And there's a mechanism by which the city can file an appeal of that opinion and hold off producing the document until the court decides. And Your Honor's frozen. You may have a follow-up question. I'm not sure.
All right, clear.
But again, we're talking about the very limited mechanisms that might apply. I mean, even what we're discussing there is a 3-2-1 mandamus action. There is no 3-2-1 mandamus action in this case. They dropped that claim. And even had they maintained it, every single case we have tells us that that the mandamus claim is no longer in play. It's moot. I do want to reach real quickly as we're approaching running out of time. You know, what again I want the court to focus on is the mootness issue first. And the mootness issue, frankly, once you address that, you don't have to address any of the mechanisms that may or may not be available. A mooted claim is a mooted claim. But to the extent you do need to address the mechanisms available, 3-2-1 is not pleaded here. 3-2-1-5 is not available here. And the Uniform Declaratory Judgment Act is not available here, as again articulated very clearly by the Third Court of Appeals just a few months ago in Austin v. Doe. So with that, I will wrap this up and have Mr. Lovins have his piece.
Your Honor, may I proceed?
Yes, you may proceed. Thank you.
Thank you, Your Honor. May it please the court. My name is Michael Lovins, and I represent Terrell Putnam, who is a citizen of the city of Georgetown and who requested information. And only 685 days later, he got the information that he requested. And he only got it because he filed a lawsuit. And finally, the city said, okay, we will give you the document that you requested. But they didn't just give the document, they gave the document along with a very clear and unambiguous statement that they have repeated over and over and over again, that this document is not exempt from disclosure under Section 133, the competitive matter exception of the Public Information Act. The question before the court is whether a municipality like the city of Georgetown can, as a practical matter, amend the Public Information Act to require citizens to file a lawsuit in order to obtain public information and then avoid review, continued refusal to comply with its statutory obligation to govern transparently. In other words, is this case moot as a result of the city's production of the requested document, this payback analysis or so-called payback analysis, but in spite of its continued insistence that it is accepted from disclosure? The district court agreed with us and said, no, that does not moot the case, and went further. And although the summary judgment order is not on appeal here, the district court has already ruled that the document produced by the city is not exempt from disclosure. So what the city's trying to do is to moot this case by agreeing to relief that is narrower than what Mr. Putnam requested. And that does not work. And furthermore, this case falls into two exceptions to mootness. It fits both. It is both not moot and fits the definition of two exceptions: the public interest exception, which has been explicitly recognized by the Austin Court of Appeals for roughly 30 years and was reaffirmed within the last month in State v. City of Austin. And then it's also, it falls under the capable of repetition yet evading review exception. I want to go back to what Mr. De La Fuente said at the very beginning of his argument. He said the important fact here is that the question is the payback analysis subject to the competitive matter exception, Section 133? We agree that is the operative question. We don't agree on the answer to it. And the city has vastly and repeatedly said this is not subject to disclosure under the competitive matter exception. They can protect it. But that argument respectfully doesn't work, because again, they're agreeing to relief that's less than what Mr. Putnam requested. Mr. De La Fuente also points out there are a lot of cases that say, okay, once the document has been produced, the case is moot. He's correct that there are a lot of cases that say that. He also correctly points out that those cases are almost exclusively, I'm not able to think of an exception to this. They're always under the mandamus provision of 321, not 3215. It is an open question in the Austin Court of Appeals whether 3215 confers a private right of action. But it is, and I don't want to segue to the sovereign immunity just yet, but we can get to that. It is an open question here. But with respect to mootness, one of the things that is important to note is, yes, our claim for injunction was mooted by production of the document. And so in our amended petition, we withdrew that claim because the document has been produced. But the city did not agree to the declaratory relief. And the city, and in the Bear Metro Water District v. City of Bulverde, which is an Austin 2007 case that was in 2016 cited and quoted approvingly by the Texas Supreme Court in Matthews v. I'm going to pronounce it Counts, Kountzesd. The burden, and this is not an exception to mootness, this is in mootness itself. The burden to show that this this conduct is not subject to repetition and will not continue lies with the city. And the court has said that the city has a heavy burden of persuading the court that the challenged conduct cannot reasonably be expected to resume. The conduct of the city in this case tells us very clearly that this conduct, that is, whenever a request regarding energy is submitted, it's just as a reflective refusal. It's just said, no, it's competitive matter. And their conduct shows us that that will continue beyond this case. Going back to the Matthews v. Counts case, the Supreme Court said that subsequent events must make it absolutely clear that the challenged conduct could not reasonably be expected to recur. What we have here is exactly the opposite of that. All of the events that have happened in this litigation showed us that the city will continue to withhold any document that is even remotely similar to this, as long as it's not this very specific document. Their conduct in refusing to agree to the declaratory judgment that we've requested and that the district court has already granted. The peculiar fact here is, at the time Mr. Putnam requested this document, and Mr. De La Fuente referenced this, but I think it's worth highlighting. At the time that this document was requested by Mr. Putnam, it was already on the city's website, and it had already been used in a city council meeting. There was no reason that this document should have been withheld. I don't understand exactly why the city refused to produce a document that was already produced, but that is the set of facts that we have. Furthermore, I think it's worth noting that the Section 133 competitive matter exception has been ruled to be a mandatory exception. The importance of that fact is a mandatory exception to disclosure means that disclosing that information is actually a criminal act. So what the city is saying here by saying this is not subject to disclosure, but we will disclose it, they're admitting we have committed a crime and we will commit the same crime in the future.
Counsel, if I could interrupt you and kind of ask this question on the potential for review or this happening again. I mean, let's say that there's a project in the future that the city of Georgetown asks for another one of these payback analyses and gets it. And then for whatever reason, I mean, maybe they don't make the mistake they made here of inadvertently disclosing it, I guess, on a website so that it's not public. They've taken the position that we're not going to produce this short of a court order. So, I mean, doesn't that, and you just said that they can't produce it because if they did, it would be subject to criminal penalties. If that in fact is the case, doesn't that mean that the next time this happens, that a court would confront this and therefore it would be reviewed by a court and a court would determine whether this competitive analysis exception applies or does not apply to the payback analysis?
I don't believe, Your Honor, that the court would ever have the opportunity to actually review it if the city of Georgetown gets their way in this case, because what their conduct here indicates will happen in the future case is they will withhold the payback analysis, wait until they get sued, And then if they get sued, they will produce it and say, we don't have to produce it, but we're going to produce it. And the pattern will continue, and the city will have succeeded in effectively amending the Public Information Act to require a lawsuit before producing a document, and it will never be reviewed. And that's what they're trying to achieve here. And the definition of the conduct here that the city would like to have is the conduct relative to this very specific piece of paper. But I don't think that's the correct definition of the conduct. I think the better definition is wrongfully withholding information pursuant to a purported competitive matter exception. And I think, Your Honor, your hypothetical here is exactly on point, because a payback analysis, we contend, is not subject to the competitive matter exception. Certainly not on the timeline that this one was requested and ultimately produced. Because even if it, let's say that at some point it was a competitive matter, it can't forever be a competitive matter after the project that on which the payback analysis is performed is actually completed, which that is the case here. The Lubbock firefighters case out of the Lubbock court, and it's from way back in the 1980s. It examined a case where there was a firefighter, last name was Alexander, and he wanted to file a grievance, and he wanted to be represented by the union. And the city said, no, you can't be represented by the union. So the union and Mr. Alexander filed a lawsuit. The city then entered into an agreed order and said, for purposes of Mr. Alexander's grievance, we will follow the following procedures and allow the union to represent him. And so then once that grievance procedure concluded during the pendency of the litigation, the city tried to say, okay, now this is moot because we already did that. But the court saw through the gamesmanship and they said, no, this is not moot because you're still refusing to agree that what you did was wrong. And you're refusing to say you're going to incorporate the terms of that order into future grievance proceedings. That's precisely what the city is doing here. They're saying, oh, see, we will comply with this particular request. But in the future, implicitly what they are saying is when we get more competitive matter, something about our energy program, which has been at the forefront of their public relations campaign, and God bless them for trying to have green energy. We're only asking for transparency regarding the finances of that. But when a question about the energy comes in, they reflexively refuse to produce it, and they get the AG opinion. And Justice Rodriguez, I believe it was your question about this, that isn't that opinion advisory? And of course, Mr. De La Fuente conceded that it is. And furthermore, it's not, except in very rare cases, adversarial. So none of those really qualify as a review of this exception. The other thing I think is important to point out is Mr. De La Fuente wants to have what provision of law is subject to review be the Public Information Act. And he uses as his example, and it's a good example for his argument, the attorney-client privilege, which is exempted from disclosure. And he says, well, see, the Public Information Act gets reviewed all the time. But none of those reviews are remotely helpful to understanding what Section 133, the competitive matter exception, means. The attorney-client privilege is well defined. I mean, it goes back how long? A very long time. It's been reviewed countless times. We couldn't, if we did a Westlaw search, we couldn't even possibly count how many times it's been reviewed. There can still be some disputes over it, but we know basically what it means. This has never been reviewed. The competitive matter exception has been reviewed precisely 0 times by the appellate courts of the state of Texas. It has been cited, I believe, twice. One of them was simply to say that it's in conflict with the PUC rule. It has nothing to do with what it actually means. And I forget the other, but it had nothing to do with what this competitive matter exception actually means. We need some guidance on this because this energy program is a very important public matter. We just saw, in fact, Mr. De La Fuente and I were on a sound check for this hearing that was set quite a while ago. I was in a stocking cap in my car so that I could have power from my charger in the car because I didn't have any in my house. We saw just a few weeks ago just how important our energy program is. nothing could be more in the public interest than the energy programs that are being run by governments, because as a self-governed people, we have the right to know what our government is doing.
Council, if I could interrupt you again, and I'll just tell you kind of one thing that I'm struggling with is, you've got the Gates opinion that kind of builds on Giggleman and builds on City of El Paso. And Gates seems to kind of check almost every box on the issues that we have in this case, mootness and the recoverability of attorney's fees. And then I think in footnote 4, it actually talks about 3215 actions. And I have not read the newer cases that they've cited, but tell me how you get around Gates and the cases that it cites.
Sure. So the Gates document, or the Gates case, the documents were produced, and then the plaintiff requested some declaratory judgments. And he didn't really request the kind of declaratory judgments that we're seeking here. He wanted to know about the reasons, or actually I think it might have been a she, but the plaintiff wanted to know about the reasons, the motives, or the delay in producing these documents. And the court said, well, sovereign immunity is not waived for that. And it also appeared that the declaratory judgment claims, they were filed kind of trying to make sure that the case remained alive. It wasn't trying to get a ruling on what is a pretty well settled, again, I'm pretty sure I'm correct that Gates was, which is an unpublished Austin opinion, was about the attorney-client privilege. It was a peculiar family law situation. And the claim of the plaintiff, who actually was not the requester, it had been her husband who was the requester. That's another important detail. The claim that she made was that their failure to produce the documents that she requested and that they contended were attorney-client privilege had harmed her in some other case, and she wanted to know why. And the court said sovereign immunity is not waived for that purpose. But that's not the purpose for which we're seeking a declaratory judgment. We need guidance from the courts of the state of Texas on what the competitive matter exception means. We have none. This is an important matter, and we need some. With respect to the city's interpretation of 3215 to not include a private right of action. First of all, the 2nd, 7th, and 14th courts have said that there is a private right of action. The other thing that I think is important to note there is prior to the amendments to the Public Information Act, approximately 15 years ago, as I recall, it was very clear that a requester could file a suit for declaratory judgment. That was very clear. If you keep reading down to subsection K of 3215, that makes it clear that the action authorized in 3215 is in addition to any other causes of action that already existed. It does not expressly or implicitly restrict a pre-existing right of action. In fact, it explicitly says pre-existing rights of action continue to exist. So what 3215 is providing in the section that says I believe it's the county attorney or the attorney general may bring an action on behalf of the requester, that's providing a different cause of action, a different avenue for the requester to get the relief to which they are legally entitled without having to do what Mr. Putnam had to do, which is hire attorneys, incur expenses, all that sort of thing. And it's also important to note that is the reading that Georgetown wants to give us is contrary both to the spirit and I've discussed the letter of the law, but it's also contrary to the spirit of the law, which in the first section of the Public Information Act says that the people do not give their public servants the right to decide what is good for the people to know and what is good for them not to know. But the city's reading of 3215 says we're only going to let a public official decide when and if to bring a case under the Public Information Act to get that declaratory judgment and find out what the people have a right to know. The people have a right to know, and that's what the Public Information Act is for. It couldn't be more clear. And the gamesmanship that the city has engaged in here with demanding that Mr. Putnam wait 685 days, hire attorneys, file a lawsuit in order to get a one-page document that I don't know if the city knew that it was public or not. All of the communications up until Mr. Putnam through us told them it was public indicate they had no idea. They never said, oh, this document was already public. And the nature of the document is that you can't really tell it's a payback analysis. If I were running a payback analysis in my business and I did it like this, I wouldn't be doing a very good job. That's not really the issue here. The issue is this is not a hypothetical dispute. It is not a theoretical dispute. It is a very clear dispute on very clear facts, and the application of the law to these facts is important for the public to understand what this particular law means. It's important for the city to understand what it must produce. And we ask that this court would affirm the holding of the district court, which said this is not a moot case and their sovereign immunity has not been waived. If there are no further questions from the court, I'll yield my 35 seconds back to the court.
I do have a question that I hope isn't too difficult to answer in this short amount of time, but can you address the attorney's fees issue if, even in the worst, even if there was a decision made that the case is moot? Let's just go with that area.
I don't want to make that concession, Your Honor.
Right.
I think whether the attorney's fees dispute remains live depends upon the avenue through which, and I see my time's expiring, may have 20 seconds.
I'm assuming Justice Rodriguez would allow the answer.
Okay. If
I said yes.
Okay.
Thank you, Your Honor. If immunity is waived,
Go ahead, I'm sorry.
if immunity is waived under the Public Information Act, and that is the only avenue through which we get to this suit, I think we have a very hard time recovering our attorney's fees because it's a substantially prevail standard, and I disagree with what the standard is on that in terms of the so-called voluntary production is not substantially prevailing, but that is the standard right now. If we're under the Uniform Declaratory Judgment Act, it's a discretionary and equitable award of attorney's fees. And so in that case, I think we would have the right to recover attorney's fees.
Thank you.
Thank you, Your Honor.
Mr. De La Fuente?
Thank you, Your Honor. Justice Alley, I did want to answer your question. I told you I'd get back to that. The record site you were asking for is 228 to 234 on the 418 times it's been raised. And as to something that Mr. Levins raised, is this how dare you set up an awful scenario where someone might have to sue and actually get a judgment from the court to get the document, and this is the wrongful conduct we're seeking to abate. The Giggleman and Deere decisions involved not just a mandamus suit for the recovery of document, but an interlocutory summary judgment that said, entity, you're wrong for withholding this. You need to give it to them. The entity produced the document. So even having been found wrong in an interlocutory order, the entity produced the document and the case was mooted. Production moots the case. I mean, and it really kind of, the end point that Mr. Levins reached at the end of his argument is an important one. They want an interpretation of the exception, but they can only get an interpretation of the exception, the public power exception, as it applies to this document in response to this request. And that's all that can be done. And as to this document, the issue has been entirely mooted. So filing a suit to compel production is requiring a suit to compel production is wrongful conduct. If that's so, then the case law in the history of Texas is replete with horrible bad actors, because there's case after case after case construing these exceptions where the entity did withhold. And sometimes the entity's right, sometimes they're wrong, just like when I assert the attorney-client privilege. Most of the time I'm right, sometimes I'm wrong. But it always, they're always mandamus cases because that's what's available to the requester. And I do think that to bring you back to the 3215, Justice Alley, you're right. Gates ultimately avoided ruling on it, and I can absolutely see this court doing the same because the mootness will dispose of it. and that's exactly what Gates did. But the 3215 vehicle, at least as addressed by Gates, acknowledges that conundrum, and the order of operations is stated in the case from last week in the Qatar Foundation states that exact order of operations. Your right is, as a complainant, to go to the DA and county attorney, which, by the way, is how we redress ourselves for crimes committed against us. I go to the DA and I file a complaint, and they may or may not bring a charge. So that's not outside the bounds of the way that the order of operations works. But again,
Counsel,
yes.
Oh, I'm sorry. I don't want to get you off your thought train, but I did want you to address who carries the burden on capable of repetition yet evading review, not just to show it's moot, but then you have these exceptions, and who carries the burden? Do you have the burden to disprove the exception, or do they have the burden to show that the exception applies?
They have the burden to show that the exception applies. The burden that Mr. Levins was addressing was the burden to show that the conduct is not wrongful. And the conduct alleged here is not facially wrongful. It's not wrongful to raise an exception. We might be wrong about it, but the act itself is not wrongful. The act itself is provided for by the legislature. And in fact, as Mr. Levins noted, this exception is above and beyond even many of the normal exceptions, in that it has even criminal sanction attached to it if you don't assert it when it applies. I mean, there's an obligation under penalty of criminal law to assert the exception when it applies. So it is not only not wrongful to assert it, it's arguably wrongful not to when it's, actually not even arguably, it's criminally wrong not to when it does apply. Now, there are reasons that it may no exception may apply, and or this exception may not apply. One of them he raised, and it's an important one, is timing. A piece of information that may be competitive public power information in 2016, as time passes, may no longer be competitive information. It may change in character. And at that point, you know, if the issue is raised, the city goes back and looks at it and says, you know what, you're right. This is now no longer subject to that exception. It's not subject to any other exception. Here, it's a public document. The point is there's multiple reasons that the excluded or accepted nature of a document from public information disclosure could change over time. And the obligation of an entity when confronted with that question, when re-examining it, is to make the proper good faith answer of, well, you're right, this is stale information, it's no longer competitive, we're producing it. Or it turns out this got disclosed some other way, maybe it shouldn't have been, maybe that was a really bad thing to have done, but it did, and we can't stand in front of the court and lie and say it's still no longer subject to disclosure. Give us a hypothetical ruling on whether it really is attorney-client privileged or not, as our analogy goes, even though here it is, I published it on the front page of the newspaper. I would presume I'd get sanctioned by a court if I was standing in front of it arguing, yeah, but still deem it privileged, even though I admit that I published it on the front page of the paper. The incentive here is actually a positive one for governmental entities when confronted with an issue, and maybe even an interlocutory court order like Giggleman and Deere, to make the document public and moot the suit, as opposed to be dragged into litigation seeking what is fundamentally a hypothetical opinion and examination of this exception. And I'm aware that Mr. Levins wants an examination of the exception, but the question is not, has it been reviewed? That's one way to decide that something is reviewable. But the third court precedent in Gates has already ruled on that. Public Information Act exceptions in their entirety, as a matter of law, are subject to review. That's not a debatable point. And now that we've established that, if the point is, well, I need you to take this up because this exception is not subject to review, that's clearly at odds with what Gates found. And Gates is, again, we're in a docket leveling situation, so Gates is binding authority on this court in this circumstance. As to the policy arguments, the legislature, while the legislature pronounced at the top of the Public Information Act that public information is very important, the legislature also decided that the public power competitive information must be protected, and it's so important to protect it that it attached criminal sanction. So that the public policy argument behind that doesn't really carry the water either. He did make a reference to some pre-existing right of action that under prior versions of the Public Information Act, there may have been a right to a declaratory judgment, and 3215 saying it doesn't abrogate any existing right. But of course, as this court knows, post Took v. Mejia, we've been told very clearly that waivers of immunity must be by clear and unambiguous legislative pronouncement. So if the legislature had a cause of action way back when, but has now taken it back, that's where we stand, and the legislature has spoken. This isn't a savings clause to say whatever statute we had before is still alive. It's not there. There is no declaratory judgment mechanism available. As to the conduct here, again, we raised the issue of timing, and I think also that it's wrongful conduct. I think he raised the Bearmet v. Bulverde case, which I think is a very important contrast. If the conduct on its face alleged is illegal, and in Bearmet it was you're acting outside of your enabling legislation by doing this act, that is on its face illegal. If it's on its face illegal, like Click v. Tyra, which they lean on in their briefing, you're charging for transcripts. You cannot do that. That's wrongful conduct. Here, the conduct facially alleged is you're asserting an exception that the legislature has expressly provided for and actually obligated you to assert when you think it applies. That's not wrongful conduct. We might be wrong in how we make the call. I mean, certainly the Attorney General regularly looks at cited exceptions by governmental entities and says, yes, it applies here, but it doesn't apply there. Yes, you should withhold these documents, but not these. It happens literally every day. The Open Records Division of the Attorney General's office is a very busy place. So that sort of consideration, that sort of action, asserting something in any good faith, getting an Attorney General opinion, which, by the way, this is in the record, agreed with the city's contention, can't be a wrongful act. The city, again, would be wrong if you want a wrongful act. The city would be wrong if it doubled down and on later finding out that a document was public, didn't agree, yes, you can have it.
Counsel, can you just in your last seconds address the UDJA argument on attorney's fees?
Yes, and the real look. There's a very clean and easy way to deal with that. The Austin v. Doe matter says it's not available in a matter seeking an adjudication of your rights under the Public Information Act. It's just not a door through which you can pass here. And again, we'll send the court a copy of that case. But that one makes it very clear. The door has been closed on the UDJA multiple times, including by the third court as recently as this December.
Thank you.
And with that, I yield my 20 seconds. Or no, I ran over.
Yeah. Anyway, thank you so much, gentlemen. We really appreciate your spirited argument this morning. Your case will be submitted based on the briefs and the records, and your answers to our questions this morning. We appreciate it, and we appreciate your participation. Thank you.
Thank you. And Your Honor, I do, and Mr. Lovins, while you're on, I do have a practical question. There are 4 new cases that I referred to in my argument. I would like to send you just copies of those cases under a plain cover letter. I presume that's how you prefer to receive it.
That's fine. And if there are any other cases as well, Mr. Lovins, that you want to send to the court, we're happy to look at them.
Thank you, Your Honor.
All right.
Thank you, Your Honor.